rolling. As promised, I'm going to address some questions that were delivered during our break. Let's look at a few of these. Are we liable if a child gets bitten by a snake on the playground? Good question. I mean, someone was listening. If we are next to a swamp or a pond or something, and we have a history of snakes coming through particular areas of the playground, then I can see someone making the argument that, look, since you're dealing with young kids and you do your proximity to this area, that you ought to have a teacher walk around there and check before the kids go there. Or perhaps you need to move the playground to a different area, or perhaps you need to put up a barrier. We have facts like that. We could have some exposure. And I mentioned that all the time in these presentations. Our exposure also depends on where our campuses are situated. If our campus is right next to a railroad track, if our campus is right next to a pond, if our campus is right next to a 4-lane highway, then our liability is going to be different than it is out in a little white 2-lane area in the hills. Okay? So it depends on the factual circumstances. But as a general rule, if we do not have a history of having a snake infestation, then we're not going to be liable, in my opinion, if a kid is bitten by a snake on a part of the playground. Okay? Unless we knew or should have known that there was a problem, then I think we're going to be okay. Let's use, since we're so close to LaSalle, and I've got a case like this in Webster, bats. Okay? I have a case in Webster now where a lady is on sick leave, but she's teaching for the community college on the same campus at the school after school hours. And she claims to have been chased down the hall by a bat and claims to have fallen. And so there's a whole bunch of issues there, like if she's too sick to work for us, why is she teaching after hours for someone else? But there's also that little thing that we've never had a bat in that building before. So how was it foreseeable that if there was a bat, that we were negligent in some way? Okay? So I feel pretty good about that case. So to answer the question straight and head up, if we have a situation that we have no knowledge of there being a problem, then we're not going to be liable. It also reminds me of a case in Bossier where they're building schools left and right up there because of the population growth. We have complaints that someone was coming to the school and instead of following the sidewalk, they tried to cut an angle through the grass, save a few steps, and they twisted their ankle. And when I was doing the research for that, I found a case where it said it was a relatively new school, the grass had been sodded, and that a nice, pristine, wide sidewalk was provided to the pedestrian public for their safe use, but that this this parent, in their haste to get there, cut through the grass and fell in a hole that the school board had no knowledge of. And so the school board was held not to have any liability there because, number one, they didn't know the hole was there. Number two, it was fairly new yard. Number three, and most importantly to the court, they had a nice, beautiful sidewalk that had they used that sidewalk, they would not have found the hole. So again, was any of the stuff foreseeable? But that was a good question. First, next, I want to apologize for the bus operators to the extent I offended anyone because I'm archaic and didn't realize that you're no longer a bus driver, you're a bus operator. And I, again, told you my grandfather was one for a long time, so certainly appreciate the bus driver. Let's see, there was a question about teaching in both the shop and in the kitchen settings, and what to do if a kid fails the test on safety rules, or if they don't do well on that safety. I would reteach that student those rules, and I would keep testing them until we could get right at that 100% efficiency. Because that will again show that you did your job to make sure that the kid was instructed and knew the materials before you turned them loose on something as dangerous as a power saw. So I do recommend that you retest and reteach that area until they can demonstrate proficiency that we need. Another good question that came up was about supervision of students. There's a case, Walmuth, W-A-L-M-U-T-H, to be Rapides Parish School Board. So Louisiana Supreme Court case, and it's good because it says this: reasonable supervision of kids is what is required. You can't always have 100% supervision. It's impossible. I had a case in Claiborne where the teacher was terminated this year. We were able to show that while the teacher was in the class, the kids were getting up, going to her desk, going to some inappropriate sites and printing off inappropriate pictures while she's over here helping some other kids. So you can't lose focus that while you may be helping one student, you've got 20-something others in the room. We had another teacher in a parish that was terminated where, despite warning, she would bring all her pills to school, like in a Ziploc bag, and leave them on her desk in an elementary setting. Then she would go to the back of the class at a station that she had set up, and the principal would walk in, and there would be the pills sitting right there within easy grasp of any of the kids. They warned her about that, but it got to the point where it was just a safety act. This is the same teacher that would go next door to the teacher next to her and go, "Will you come tell my kids they have a mind?" This is that teacher you remember I told you about using the leaf blower to clean out her classroom. Her class was so dirty, they couldn't vacuum it. It kept burning up vacuum cleaners. So they'd use a leaf blower, blow the trash out of her class out to the hall where they had the tile floor, then they could sweep it up. So she had a few issues. Classroom management control is extremely important. You can be the most intelligent, the brightest teacher, but if you can't make them sit there and listen to you, it doesn't matter how bright you are. So that was an issue. Now, also on supervision of kids, this Walmuth case is important because it dealt with bathroom duties. This was a male coach that had a co-ed PE class. And so the issue is, what happens if something goes on in the bathroom? Okay? And the Walmuth case, the principal would station himself in the gym while the kids were dressing in. He would be between the boys' room and the girls' room. And because his kids dress out, they come back into the gym, or dress in, they come back into the gym. The court said that teacher could not be in all places at all times. The court also said that the school board, it would be impractical for them to hire 2 people in every gym class. Rapides is a pretty good sized district. So the teacher stationed himself in between the 2 restrooms while at the same time watching the gym. And his rule is that if he heard a commotion in the girls' room, that he would knock and give them a few seconds to get decent, and then he would come into that dress room. Now, that's not optimal, but that was the rule that they utilized there, because just you can have some hellacious fights with ladies. Well, I tell you what, when those girls start after the hair and the nails and the biting, it can be tough. Okay, but that's what was done. And so what I'm advocating here is that you not necessarily do what that person did. I want you to have a plan that will allow you to handle those type situations. If you know that a particular area of your school is a problem, like a particular boy's bathroom, then you can visit with your principal about having someone of the opposite sex in that area, at least for a period of time, to address the issues that may be going on there. If, though, you have a situation where you have a special needs student, or you have a situation where you, even though you're of the opposite sex, you give that warning, and then sometimes you just would have to enter. That's the situation. I hope that we can have enough people of the opposite sex that we can deal with our principal and come up with some policies and procedures in that regard. But that's the best way to handle that. But again, if you're having a problem, do not try to address it yourself. Go visit with your supervisor or your principal and let them know what the problem is, what the specific concerns are, and how you can address it. What about parents who keep dropping off their kids too early in elementary school? I know that we have a bunch of that. I know that many of you, even in food service, may experience some of that where you're still preparing the meal in the morning and kids are starting to come in. My advice there is to, every time that you have an assembly of parents, you should set your expectations and your rules with them. Thank you for attending our fall open house. I want to remind you, you're all doing well. There is a little problem we're having with some of you on the rule about drop-offs. Here at such and such elementary school, we do not have people here before 7:20 to supervise your kids. So if you leave a child here before 7:30, whatever it is, then you're leaving them in an unsupervised area, and we're telling you that. So it's not safe for your kids to be here. We want to put you on notice. If this continues to be a problem, we will have to address it. Okay? And then the way we'll address it with them is by individual letters to them, telling them that they persist in violating the rule. And the last couple letters will mention that if they continue to do so, we'll have to contact Child Protective Services. Usually that's very effective when we go that route, but we only go that route if we have given them adequate warning. It's posted on our website. We've mentioned it in various letters. We really use that as an issue of last resort. But just think about it, folks. If you tell someone you shouldn't leave your pre-K child here before a certain time, they're not being supervised. That's about the same as taking them down to Walmart and dropping them off. You know, they've been warned, and that's the way that we handle it. Now, if you're one of the food service workers or the teachers or parents that are on campus and you see a kid at 7:15 heading up the power pole, I told you this before. You can't look at your watch and say, that's not 7:20. Just let them go. Once the kids are there and we know they're there, then that triggers our obligation to take care of them the best that we can. Okay? So as a policy, perhaps your principal says, or he or she, that when kids are found to be on campus before hours, we're to take them to the gym, and then we'll rotate having a teacher on duty that will, not on duty, but we'll rotate who's there to watch over them until appropriate time. So if we know that the kid is there and we are there ourselves, then we can't ignore that situation. Again, these questions are helpful. Planning periods are for planning. Check with your principal before you leave campus. There likely would need to be a good excuse for you to leave during your planning period. You would certainly have to sign out, but planning periods are for planning. Sick leave days. Sick leave days just don't poof and go away. Each employee is going to get 10 days of sick leave per year. At the end, when you retire or resign, or fortunately if you pass away while still working here, there's a statute that says that you can be paid for up to 25 days of your accumulated unused sick leave. Then when you seek to retire, your unused sick days can count as service credit up to certain maximum caps. In addition to that, for teachers, if you leave Caldwell Parish and you have a sick leave voucher, that sick leave can transfer with you to another parish. Or if you leave the school setting altogether and go into the private industry, come back to the school district within 5 years, those sick leave days will most likely still be on the books. So sick leave days, if they're not used, don't just poof. Okay? They are there for your use and can transfer with you to another school district. Let's see. Mandatory reporters. Surely we all know that we are mandatory reporters as it relates to a child's mental or physical health. You have reason to believe that the child is being mentally, physically, or sexually abused. You have an obligation, mandatory duty to report that. Now, if you follow the news in Monroe, in Washita, Monroe City, you know that there was a big brouhaha about 2 years ago on that. And the Attorney General sent out a refresher saying that, yes, it's awfully nice of principals and superintendents to make those type of reports, but the mandatory duty is on the teacher. And so if I were a teacher in today's climate, I would come in and report it to the principal immediately. I'd ask them to work with me in getting it reported appropriately. But at the end of the day, I would make darn sure myself that it was reported and that we had proof that it had been reported in order to protect you. Okay? So everybody in this room is a mandatory child abuse reporter, regardless of your role or your capacity. When it comes to sexual abuse of a child, some of these rules have fuses as short as 24 hours. You have to report that within 24 hours. Now, you don't have to have conclusive proof that it's going on. If you have a good faith basis or good faith belief that it is, then that triggers your duty. If you are that PE coach and you're in the female PE coach and you're in the ladies' dressing room and you see a girl, a young lady with welts across her back, then you probably are going to have a good faith reason to investigate that, at least. Just because a student says they don't want you to report it, that means nothing. Zero, zilch. We had a teacher that was arrested, actually a guidance counselor that was arrested 7 years ago. A high school senior come in and tell her that her dad was very abusive, she and her mother, but said, look, I'm graduating here in May. Here we are in April. I'm going to leave this town. I'm not coming back. If we were to report this, Dad may kill my mom or me. So it was not reported. Without anything setting him off, a couple of weeks later, he did just that. He hospitalized his wife because of the abuse. Social worker comes around, and mom's in the hospital. And social worker interviews the mom and the young lady and said, baby, you've never told anybody? Just my school counselor. Well, that's what got the school counselor in trouble. There is no such thing as permission to be abused. There's no such thing as a mandatory child abuse reporter weighing it and saying, am I better off not reporting this, or should I report this? No, that's not our job. Our job is to make the report and allow law enforcement and social services to do that weighing and balancing. So if you want to make sure that if you become aware or have reason to believe that there's a problem, then make darn sure that that gets reported. This summer they added a law on threats. We are mandatory reporters now if we have threats of terroristic acts or acts of violence in school. So if you hear a kid say, I'm going to shoot up here tomorrow, or if you read a Facebook post that talks about a potential threat at school, we have a duty to report that as well. And law enforcement will come in, they will interview the child, they have the opportunity or the option to file something immediately with the court. The court can sign an order saying the kid cannot return to school until such time as they've been cleared by a mental health counselor. The court can even set hearings on this. Now, everything I just told you is the 30,000-foot view, because we don't need to get down in the sand and the nitty-gritty about what all we do with this law. My role here today is to let you know this is an issue. It falls on the heels of all the school shootings that we've been seeing, shootings in churches. recently as this past week. So if you have reason to believe that something relative to the safety of the campus is being impacted, you must report that as well. It's part of our duties as mandatory reporters. Now, confidentiality. If we make a mandatory report, obviously we hold that in confidence. But in addition to that, confidentiality in the school setting is much broader. We don't talk about co-employees' medical conditions that they may confide in us. We don't talk about students' grades or what we think of students' parents and not think of those parents. These are things of confidential nature. Same thing with grades, highly confidential. As it relates to grades, I want to break this down a little bit further and talk to you about the law on grade changes. Back in the 90s, this was a hot issue. It kind of died down for a while, but here recently, it seems as though we've had a new push. We're seeing more and more allegations of grade changes. In my little notes, I have coaches beware. Eligibility looms large for some coaches and athletes. There's a case out there that says eligibility and athletic success may loom large in the eyes of coaches, students, and their parents. It does not appear as a large issue to this court. So education is what the courts are looking at. If you change a grade to make a child eligible to play, or if you change a grade as a teacher at the request of a coach, then you are all subject to serious discipline. So please be mindful of that. And I can assure you that the folks at J-PAMS can tell amazing things. Y'all use J-PAMS? They can basically tell you who did what, when, where the changes were. So be careful there. Be careful to hide what you're doing, but be careful in that you make the right decision. There, this situation I told you about in Bossier, where this guy was doing this. His wife was also a teacher. She was on. He had a good salary, and now he's in jail. And if you're arrested on a sex offense, the school board cuts your payoff immediately. So they went from a 2-income family to a 1-income family. I'm sure. Think of how that would impact you if you suddenly lost your job. And it doesn't have to be on a sex offense. If you are just a 2-income household and one of us does something stupid like change the grade, we suddenly become employed, that has an impact. I guarantee you, if you do something like that and you lose your job here, that will have an impact on your ability to find another education-related job. So please think of this and not this. But grade changes are an ongoing issue. Now, it is not acceptable to say, hey, I'm not going to use Johnny's name, but I'm going to get out and I'm going to blast that guy, that kid lives over there by the such and such place. If you use enough information that we're able to identify the kid, just because you didn't use the kid's name, that does not mean that you have not violated the law. If you are talking about kids in a manner that allows others to identify them, then you're just as guilty as if you use their name. So be careful in those type of conversations. Now, let's talk about emails. If you work for a public school system, that means that your emails, if you have a Caldwell EDU or whatever, all of our employees have. We can receive a public records request for your emails. And we have to print those emails off and give them to the people that request it. Now, obviously, we have to go through and take out stuff that relate to kids, take out stuff that may relate to your sick leave thing. But here's what we're getting a lot. Let's say you have a hot parent-teacher conference, and you've got a math department or a math, what do we call it, not department, all the math teachers, maybe it's the math department. The parent sits down with the math department and the principal, or the teacher, one teacher sits down with the parent, and it gets very heated. Maybe there's some name callings and some disrespect. Well, natural tendency is, if no one's there, to maybe send out an email. You won't believe what that nice guy said to me. He said, blah, 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 blah. Poor child, can you imagine having to live with that? Send out something like that, and we get a public records request for all your emails where the parent says, please produce a copy of any email discussing me or my child, which came from Mr. Geis's office between January 1st, 2018 and September 1st, November the 1st. We would have to produce that document. And that's not going to give that other person a warm and fuzzy. You may not care, but it can create some bad issues. So be very careful what you're putting out there on the emails. Those of you that are coaches and you're members, obviously the Athletic Association, certainly would be good if you had an alternative email address, particularly if you're on the executive committee. Because what we're seeing is that school employees, particularly those on the executive committee, are talking about a lot of confidential stuff, and we get public records requests, and that means that we have to have our IT person go through all your emails and pull out all the emails. I know last year we had a big stink of the executive director position at the Haskell Athletic Association. And there was a particular writer in the Baton Rouge area that wanted to know what everybody in the association was saying about Bonite. So be careful on these emails. I know you're thinking in your head, talking to a buddy, not talking about school. This is coaching stuff. This is the Athletic Association. It's coming through that Caldwell EDU account. It's going to be a public record. It's going to be something we have to produce. Folks, I tell you, I saw some things on there that some principals were saying and some coaches were saying that they paint people. And it's something. So this is the public records component of what you do. So just think before you talk, think before you type. Just don't disengage your brain, okay? So we'll talk about that. Also want to talk a little bit about the inappropriate relationships with students. So that's a big one. I'm not going to recover stuff we've already talked about, but there's a concept called grooming, where a male teacher or a female teacher starts talking with kids about innocuous things that don't have anything to relate to sexual matters, increases the comfort level, and eventually heads down the wrong path. For this reason, our legislature has said that students and teachers and other school employees, this is not just a teacher issue. I've got a substitute teacher had sex with a student 2 weeks ago during the pep rally. She set up through Twitter. She and the board were talking through Twitter. And when the rest of the class went to the pep rally, she and the male student went back to a classroom and had their own pep rally. So anyway, be extremely aware of the fact that if you communicate with students about homework, it is supposed to come only through the Caldwell EDU account. Not supposed to be texting students, doing all the types of chatting, all that's done in all these other places. Now, there did soften it up some in some parishes that allow you to come in and get parental and principal permission. Like it says, I am the coach. I need to communicate coach game practice times. Everybody signs off on that, and conversations limited to that are permissible. But folks, with today's apps on phones and all, they have third-party apps that allow for announcement of practices and when the bus is leaving and stuff like that. So there's no need for that one-on-one deal. And you send it out, and it goes, the same message goes to all teammates immediately, and there can never be any question that you had any inappropriate motive or ideas there, because it goes to everybody, including the parents on that list. If you're not that sophisticated and don't want to do that, you can have the team captain send out those type of messages to the students on the team. So all I'm suggesting to you is that there are laws that say that you have to be careful about your social interaction, electronic interaction with students. In addition, there are many teachers out here that are right out of college. You may be the early 20s. Some of the students that you're teaching may not be much younger than you. And your thought process may be, well, look, I'm 21, 22. This student is 18. It's legal for me to have a relationship. The age is 21. If you are an educator and you're at a school where there is a student 21 or younger, then it's going to be a serious offense, a criminal offense, if there's that relationship. I'll submit to you that it's not acceptable under your policies. Now, 21 deal I told you is state law. Under your policies, those school employees are supposed to be having a relationship with a student in our school district. It's simply unacceptable and will get you in trouble there. But I wanted to call that to your attention. All right. Let's talk a little bit about search and seizure. There's various rules that are involved depending on the type of thing we're searching. Here's the general rule. If the school board owns it, then we can search it. We don't have to have a reason to believe that there's a problem. So if this were a locker, and you were the principal, you could open up that locker. You could go down the hall, open every other locker, and look in it. Why? Because we own the lockers. The courts have said that kids have no legitimate expectation of privacy in that locker because they don't own it. Just being allowed temporary use of it. The principal can look in every locker. When you open that locker, if you see a shotgun in that locker, the fact that you open that locker is of no moment. You can confiscate that shotgun, call law enforcement, discipline the child. That's what would be expected. However, if you open that locker and you see a purse or a book bag or a cell phone, the rule changes. That purse, that backpack, that cell phone are not your property, nor are they the school board's property. Now, if your policy says you cannot even possess a phone on campus, then you've got a violation that you can punish there. But if the kids can simply have their cell phone but not use them, then you haven't found any evidence of a violation. So if it's our property, we can search it. If it's their property, we cannot search it unless we have some reason to believe that that purse, that cell phone, or that backpack contains contraband or contains something that is a violation of state law or school board policy. So that's saying that a student comes to you and says, look, the guy standing at locker 33 had a pistol. He put it in a blue book bag and hung it up in his locker. Go to locker 33, you open it up, there's a blue book bag. So I think at that point you would be extremely reasonable and within your rights to look inside of that book bag, because you're not acting on a desire to be nosy or looking on a desire just to catch somebody because you're probably bad but principle. Okay? You are acting on a specific individualized basis to believe that both state law and board policy are being violated. And so you would be entitled to look inside that book bag. And if looking inside that book bag, you find marijuana or you find cigarettes or anything else, you're going to be okay to discipline that child because the initial search was for a legitimate reason upon which you have a legitimate basis to go looking at it. Now, cell phones are tricky wicked. What is the policy here, Angela? Can they possess? You can have a phone, but they can't be on. So let's say that you take the cell phone because the phone is the only class it rents. They have violated the policy. They have disrupted your class. You can take that cell phone. You can shut that cell phone off. You can ask the kid to cut it off and give it back to you. But just because the cell phone rang in your class does not give you the authority to go looking for all the pictures, for all the text messages, for everything on the content of that phone. Because you have no reason at that point to believe that phone was being used to violate a school rule or a state law. So you can only be as intrusive as you have a reason to be. You can't just be that nuts. I don't know how to say it any other way. So if the phone rings, take the phone, cut it off. Now let's change the facts a little bit. You hear me say to change the facts. The change in the facts changes your conduct. So let's say that your custodian's walking down the hall. It's 5 minutes after 10. The custodian hears somebody whispering on the phone. He looks in the stall in the men's room. There's a pair of red chucks. Here's the conversation. He walks out of the bathroom just in time to hear the school secretary scream, "Off the ramp, we got off there." It's the principal out there. What's going on? You know, I heard a male student on the phone a few minutes ago. So at that point, if the secretary says the person was whispering, it's a male voice, it happened at the same time that the guy heard him on the phone, we're getting close there to having something, okay? So that actually happened in a certain parish, and when the police got there, they took all the kids out onto the football field, and by that time the custodian had told the principal what he observed. The principal went out there and found the kid in the stands and didn't just call him aside, but looked at the friends he was sitting with. Oh, I'm sitting there with Jay and Al and Paul. And so when they got the coast clear from the police officer, and the kids went back to class, they didn't call John in, they called Jay, Al, and Paul. They brought them in and said, "Look, we think you know who made that call." But the deal was, John went out there and bragged to his buddy, "Don't thank me for not having that chemistry." And so they came clean. Ultimately, they did grab the phone and take a look at it, and they had reason to. At that point, they had a custodian that said someone with red chucks was whispering in there. Guess what John was wearing that day? Red chucks. So all the facts gave them an independent reason to believe that they were dealing with a person who was violating school rules, and that phone contained evidence of it. The same thing with a fight. You walk in on a fight, and there is people videoing the fight, either for their personal enjoyment or to put it on YouTube or whatever kids do with it these days, then you have a reason to check that phone. I've told the story before. Some of these stories, I could write a book about some of the things. You know, we had the lady that went in the teacher's lounge and the cell phone fell out of the ceiling and hit her in the head while she was on the commode. The janitor had gone in there and put the cell phone up the tile, cut a little hole, put the cell phone up there above the ladies' bathroom. And then he tried to say it wasn't him, but he had hit the record button when he put it up there. And you can see him reaching up there and putting it up. So, not the smartest thing in the world. But we had the principal that rushed in the bathroom when the fight was going on and saw two phones recording the fight, takes the 2 phones. One of the boys got a broken jaw. So they call in law enforcement and they check the phone and they're looking at the video of the fight and the words that led up to the fight. And then they go back one too far and saw that those same 2 boys were engaged in a sex act together the night before. So the principal and the superintendent called me and said, "What do we do with this phone?" And I said, "Well, it seems to me like that contains evidence of a fight. You've got a broken jaw and a battery charge. That phone needs to be simply handed to the police when they get there because it contains evidence of a fight, and then we'll be done with that phone." So that's the way we handle that. I also had up in the extreme northern part of the state, right up there on the Arkansas line. My wife's from Arkansas, so I get the teeth with them. They had a situation where dad bought him a new cell phone, so he gave his old cell phone to his son. Like a first grade student, he took it to school, and dad had to erase the videos of he and his mom and the dad and the mom and some of the dad and mom's friends getting it on. We just say dad and mom had some younger taste than their friends too. Some of them you were like, ooh, how old is this? So they took it, the little boy was showing his buddies at school. So they took the phone. And so the superintendent calls me and says, man, I've got this phone. I looked at my watch and said, dude, it's 3:15. You better call the cops and give them that phone if you think it's some underage stuff on there. He said, why? I said, because that boy is getting home about now. When he gets off that bus and tells them that the principal took that phone, I said, Dad's coming for that phone. So you don't want to have it on you. And so sure enough, the superintendent called me back and said, man, I was just pulling out of the parking lot. He was pulling in. He said, I drove straight to the police department with it. So phones or something else. I like to call phones today's modern purse. Think about that with all the payouts that you got. It's got money in it. It's got all your accounts. Maybe some people have passwords in there. It's got your family portraits. When's the last time you asked Mom, show me pictures of your kid? And they pull something out of their purse. And everybody flips to their phone. Also found out at this concert that there's an out with a flashlight on it. So you know how everybody used to hold up their lap? Now some of them are holding up the phone or just waving the phone, and others have the cigarette lighter on the phone doing the wave. So phones are nothing more than a toolbox or a purse, regardless, depending on who you're talking to. And we have another little search and seizure. There is not a cell phone in this world that is worth reaching your hand down in a young lady's bra to retrieve. That can cost you $30,000 to pick a pair. A principal walks up to the teacher and says, give me your cell phone. He says, I don't have a cell phone. He says, look, I see your cell phone. Oh, that's not a cell phone. The principal reaches in to retrieve the cell phone. Big no-no. Don't do that. He was accused of having touched things other than the cell phone. But I hope you don't have to sit and think about that before you realize that is not a good deal. The principal could have brought the person to the office, could have called the parents down and had the parents make them give up the phone. Or called someone else. Principals, teachers, don't go in for the phone. Okay? All right. Let's see. All right, I think I've answered most of the questions that I had to try to get back on some of this. Going down to student discipline. All right, bus operators. It is not our job to discipline the students. If we have a student that's acting up, we'll fill out the forms, we'll give it to the principal. Too many times each year, we have bus operators that try to paddle. We have had a bus operator stop, pull over on the side of the road, and tell the kid, get out of my bus. You're not riding another mile with me. And the kid had to walk a couple of miles home. Okay? So be extremely careful in following your duties. There's nothing a kid can do on that bus that warrants them be put off on the side of a road. Okay? Now, if you feel as though the child is so disruptive, you stop that bus and you make a call safely after the bus is stopped for either law enforcement or for the principal. Okay? You do not take the discipline into your own hands. Now, I don't think I would ever have to tell y'all never to stick your tongue in electric socket. I have seen warnings though on that. But let me give this one to our bus operator. Do not allow your students to drive your bus. That applies to coaches too. I've got a case now at a coach, where a coach gave a kid the bus and said, look, we're blocking so-and-so, go move the bus. Not a good idea. That kid didn't stop. That kid just took on driving around, took the horn so everybody could see him driving the bus. Well, he blocked someone else in the sense of hitting something, you know. So be careful there. We've had a bus operator going down I-49. So he's driving in a seat like this, and he stands up, holds the wheel, lets the kids slide in under, and then he goes to the back of the bus because there's a fight going on back there. Well, how do we know this? We know this because 3/4 of a mile back is another bus coming along, and he comes up and sees the bus pulled over on the side of the road with the bus driver and 2 kids out on the ground behind the bus. This kid who was driving had more sense than the bus operator. And when he saw it, what was going on in the back, he pulled over on the shoulder, and somehow, I don't know how this happened, the fight went out the emergency door. If that kid hadn't have pulled over, they would have been like pumpkins on the road out there. But anyway, so all this came out in a hearing. Come to find out that the bus operator's wife was a teacher. She was on the bus asleep. Didn't know this was going on. And you can't make this stuff up. So, anyway, that's the situation there. All right, bus drivers, don't leave your keys in the bus. Bus operators, don't leave your keys in the bus unattended. Kids will crank them up. If we have an extra bus, we should not leave them on campus over the weekends and all with the keys in it. We had a kid get on the bus, and he had brought on 2 of his best buds, and they rode around the bus lot inside the chain fence. But then they ran through the gate. But when they went through the gate, one of the kids was so scared, he jumped out of the bus. So the cops arrested them all, but his lawyer was saying, look, he knew it wasn't right. He just thought they were getting on the bus. When the guy went through the fence, he knew the gig was up. Okay, so he bailed. But it come to find out, they had left the extra set of keys on the bus so that if they had somebody that wasn't going to make it, they say, I had keys or an ashtray. So just be very careful there with that type of situation. There are cameras on the bus too. We have had kids do some incredibly crazy things, and bus operators do some crazy, incredible things. And listen to this. I had this case this year in the last 6 weeks. Bus operator and bus aide. Bus operator, you can hear her too. You can hear it, you can see it. So the bus aide comes up, the bus driver says, it sure is a nice outfit you got on. I sure wish I could see what was under it. And the bus aide puts her hand over the camera and flashes. A kid happened to see and report it. So, crazy stuff. All right, student discipline. For bus drivers, I told you, don't impose discipline yourself. Same thing with our support employees. If you're in the cafeteria or if you're in the restroom, support employees, when you see kids doing something they shouldn't be doing. Now, if it is something that you can separate, something of a serious nature, drug use or all, obviously intervene there. Stop the misconduct. But I'm not suggesting that you ignore anything. Stop the misconduct, but get the appropriate people on it. Fill out the appropriate forms or witness statements the principal may ask you. But we'll let the principal take the heat for imposing that discipline. Now, student discipline law is 20-something pages long. It is out of hand. The problem is the legislature will not revise it. They just keep adding to it, and adding to it. It's gotten out of hand. It takes a lawyer to read it. If the child is age 16, but in the grades 8 through 12, and has no more than so-and-so Carnegie units, I mean, literally takes a lawyer to weed through this stuff to see what the punishment is. For drug and gun offenses, some of these crimes or some of these violations result in an expulsion from the alternative school for 2 complete school years. So if a kid messes up in November, they don't get 2 years from November, they get 2 whole school years. It's going to wind up being like 2 years in a semester. For that reason, I call it the academic death penalty. Okay? So there's some very similar serious offenses there. But when we're dealing with kids, discipline can be everything from in-school suspension, calling parents, referrals for counseling, all types of different referrals for families in need of care. It can be corporal punishment if your policy does allow and accept it. Special ed children cannot be receive corporal punishment. And it can be outright expulsion. The expulsion that you and I had as kids going home no longer applies. We have to keep kids under an alternative program or through some type of long distance learning. We're seeing more and more of the long distance computerized learning as opposed to some of the kids coming to the actual alternative schools. So I think you're going to see a lot of changes in the future there. But when a kid is suspended, start suspensions first, they have certain rights. Number one, you as the principal have to tell them, this is what you're accused of. You have to give them an opportunity to respond. And then you make the decision, am I going to suspend this kid? And if so, for how long? You communicate that to the parent, either by telephone call or through writing to the address that appears in the CUME file. Now, if the parent wants to appeal that, they get one appeal. They can appeal that to the superintendent. The superintendent's appeal is final. They can't go to the school board on suspension. They can't go to the district court on suspension. Whatever the superintendent says is final. And why is that? I mean, if you're looking at a 1 to 3 day removal, 5 day removal, short removals, it's going to be longer than that before the next school board meeting. Certainly going to take a lot longer than that to go to court. So courts and school boards and all that, they're out of student suspension. Now, student expulsions, where the child is going to be out a semester or more, is what an expulsion is defined as. That is a more of an impingement upon their rights to an education. So the courts have said that for that reason, they get more rights. They get a certified letter saying that you're going to have an expulsion hearing. The child is presumed innocent. That's a big misconception. A lot of people think that if we're recommending a child for expulsion, that it's his or her parents' job to prove that they didn't do it. That's actually wrong. The child is presumed innocent. It is your job as an administrator to take evidence down to the hearing officer to prove that the child is guilty of the conduct of which they're accused. Now, folks, I think it's a serious offense. If it's one of these drug or gun type deals, that if we have an adult witness, I think it is serious enough that when we go to an expulsion hearing on one of those, that we get a sub or get someone to cover that teacher's class and to take the adult witness down to the hearing officer so they can say, I personally observed this, or when I looked into the bag, I saw this, or when here's the tip I received, this is what they told me. That's going to be a lot better than saying, I heard a student in the hall say that she heard from her bigger sister that last week someone saw John with a knife. You know, that type of triple and fourth time hearsay gets us in trouble. So if we have an adult witness, then I certainly think taking them to the hearing is the most appropriate thing to do. Also, if we have situations where student safety is concerned, like on a drug deal or something, the courts will allow us to use written statements instead of jeopardizing the safety of those kids by having them come testify live. So that is another option. Now, on an expulsion, they go to that hearing. After that hearing is over, the hearing officer writes them and says, I have considered all the evidence, and I have reached this decision on guilt. Either the evidence supports that the child is guilty of the offense charge or it does not. So here is my decision on guilt. As it relates to the discipline itself, I find that your expulsion is the appropriate remedy. According to your child is referred to such facility for such period of time. All of that is put in that letter. So there's two things, guilt and punishment. Both of them go in that letter. At this point, if that child is expelled for a semester or more, they can appeal that expulsion to the school board within 5 days. And if they do that timely at the next school board meeting, the school board will hold an appeal hearing before the entire board. Notice I said it's an appeal hearing. No new evidence, no new witnesses. Don't get in there and play Perry Mason. You go in there and describe the appeal and describe the evidence to the school board. If we have a transcript or a tape, the school board can be given the transcript and tape, and the board votes to either affirm, reverse, or modify the superintendent or his designee's decision on the expulsion recommendation. If the parents still aren't happy after the school board does what they're going to do, then they have 10 days to appeal to the state court. Now, once we get there, the judge is not supposed to say, you know what, I wouldn't have expelled this kid. I would have probably done this. That's not what the judge is supposed to do. The judge is not supposed to substitute his opinion for that of the school board. What he or she is supposed to do is ask this question: was there any evidence that supported guilt? If there was any evidence, then he's supposed to impose whatever the school board deemed to be the appropriate discipline. Now, when I talk to school boards, I do that frequently. I remind them all the time that just because little Johnny is before them that night, that's not the only student at issue. Whatever they do to that kid for the misconduct basically sets the rule for all the other kids at that school they came from. For instance, if we have a kid that hits a teacher, that takes a swing at a teacher, and we say, well, we think that's a 2-day in-school suspension. Buddy, you're going to have open season on the teachers over there. So I try to remind board members that even though it's one child that they're actually ruling on, they have to be cognizant of the fact that every child is watching what they do the expulsion. So, all right, finally, you'll see on here, section C, defense and indemnity, except when the sheriff comes call. Let me tell you what I mean by that. Kids bruise sometimes. Okay? So you can discipline a student. You can paddle them as long as you follow board policy and all. You may administer the correct number of licks, and you may have one child that's particularly susceptible to bruising, that when the time they get home, it may look like you really abused them. And that wasn't the case. The courts have acknowledged that. They've said that some kids bruise more than others. So be aware of that. That sometimes parents don't call the superintendent and say, you ought to fire John Geis. John Geis beat my kid. John Geis did this to my kid. What they will do instead is they will go to the sheriff's office. They will file criminal charges against you for abuse or for battery of their student. Here is where the law may surprise you. The school board does not have to hire you. In fact, cannot hire you a criminal defense attorney. Now, that is where LAE, LFT, Apple, LACE, all those organizations' policy that they've got may kick in. I'm dealing with several of those now. I do know that the policy covering the alleged teacher that did the mess in Bossier, he has insurance through one of those organizations that are paying attorneys. So the school board does not have to defend you and identify you on the criminal. But if you're sued civilly for something that occurs in the course and scope of your employment in school, then they do have to defend you there. Okay? So that's the distinction, and that's why I want to call it to your mind when it comes to corporal punishment. So if you paddle a kid, if you get accused of being excessive with that, parents go to law enforcement. The school board does not have to pay up front in advance for your attorney costs for the defense that situation. Now, the law does say that if you're totally exonerated on that charge, the school board may reimburse you. The public policy here is that we don't want to pay the legal expenses of teachers who abuse kids. So that's what the law is there. And once you're exonerated, the charges are dropped, and it's up to the school board. They have the discretion at that point whether they want to reimburse you for those expenses. But the policy of the group that you are a member of may pick up that in advance. All right. Any questions on corporal punishment? Read the policy. They're very detailed. They describe the policy. I mean, how it has to be used, the witness requirements, the documentation requirements. I know y'all, I remember the joke I told you last time, which is true. Some parishes, you do have to weigh the kids. Okay? So, for those of you that haven't heard that before, earlier from me, I jokingly say that where a kid is little, like less than 75 pounds, they get one lick, two, if they're more than that. People like me, they can kill, they can under that policy, okay? You've heard that before, but the whole purpose for telling you stories like that is to know you must follow that policy. Who are the witnesses? Under what scenarios is corporal punishment allowed? Is it a progressive thing? Do you use corporal punishment the first time? Can any little offense be corporal punishment? Whatever is in your policy is what controls it. So I just urge you to read your policy. All right. Talk about the ethics board for a second. As a public employee, we're all covered by the ethics code. I jokingly say that the ethics code and common sense have never met each other. It is the most stupid stuff in the world. Let me give you some examples. Let's say that, what's the public school here? Yeah. All right. You work out at Kelly. You're the principal. Straight across the street, there's a convenience store. You need a half gallon of gas for your custodian to finish the month. Your brother owns that service. Your brother will sell you that half a gallon of gas for cost. You can't buy it. You have to drive into town or drive somewhere else. Sid Pearl, wherever you're going to go. Sid, Southern Pearl, whatever it is. They got damn good chicken, I know that. I stopped at one of those places sometimes, and after writing on the wall in the bathroom sometimes, somebody written F in second grade. I thought that was pretty cool too. You're from Catahoula Parish, you find humor in that. But see, the ethics code is so worried about relationships and people taking advantage of the fact that they've got a public job that some things that would make good common sense, they say you can't do it. There's a deceased superintendent named Butch Williams that was in Webster for many years. Before being superintendent, he was principal at Sibley. He played offensive line for Terry Bradshaw. He had some great stories, but when Butch was coaching, he needed some chin straps. On Friday before a game, his brother was running Minden Athletics about 5 miles up the road. They went up there and got some chin straps at cost. They didn't have time to drive to Shreveport. And somebody found out about it. The ethics board fined him $5,000 over some chin straps. He bought them from an immediate family member. Principals, your immediate family members can't be on your staff if you are the person that is going to supervise them. Some districts have just said we're not going to allow faculty members where the principal is in school to have an immediate family member on staff. Board members can't have employees that are related to them in the immediate family category in positions other than certified classroom teacher. Now, if the people were employed in the district before their family member was elected superintendent, then they're going to be okay. But I had a crazy case in Lincoln Parish that really emphasizes this. When they changed the law in 2012, school board members no longer hire anybody. The superintendent does. Well, there is a board member that had a relationship and had a child that he knew existed, but that's about it. No relationship. Child and the mom moved to like California. The kid, as kids sometimes do, start thinking about where their family's from, and all the kids ultimately move back. Superintendent hired him. Board member didn't know. Board member had no relationship. Somebody turned that in. I'm dealing with that right now. They're trying to find them $5,000, where the board member did not know that his son was employed in the district. The superintendent didn't know that it was his relative. And different last names. And so that's what your state ethics board will do sometimes. Get another example. Let's say I want to go to lunch with any of you. The ethics code would say that I could sit down with you, I could eat, I could buy your meal up to a little over $50. But I could not mail you a $25 gift card at Christmas. I have to eat the meal with you in order for it not to violate the ethics code. Okay? So even though I could spend $50 paying it out with you, I can't send you a $10 gift card. The gifts that you receive from any one kid in a school year is counted at $25. If you are a teacher, you cannot tutor or pay your own students after school. Now, you can tutor another teacher's students, but not your own for pay. It's some crazy stuff. I see some people out there. The ethics code and common sense are not ethics. We had a principal that was offered, Coca-Cola offered to fly him to Damascus. His brother knew somebody at Coca-Cola, and they called and said, "Hey, so we'd like to fly you to Damascus this year. We'll give you the tickets, and we'll give you the airline ticket, the tickets to get into Damascus." So those of you that know anything about golf, that's the hardest ticket around to get. It's also the most expensive. And since Coca-Cola was on his scoreboard and had donated his scoreboard, the ethics board said he couldn't go on that trip. Now, we knew that was coming. I just had to call the ethics board to get an opinion because he just couldn't accept it. Me telling him, "You can't go on that trip." He believed it when he saw it from the ethics board. Luckily, they have an 800 number on their website. You can call down there. You can say, "Hey, here's the situation I've got. I'm a teacher here, I'm a principal here, I'm a superintendent here, and I'm confronted with this situation. May I do this, or would this offend the code?" And they will give you an opinion over the telephone. Okay? So things like that are very helpful. Any questions on ethics? All right. Let's talk for a second about field trips, contracts, things like that. We touch upon some of you. If you're a teacher or a parent in the classroom, you know we take field trips and we like to get permission forms. The permission form gives you the authority of the parent to go on that trip. We can have provisions in there that if there are any medical information or prescriptions or things that we have to be aware of the child that they can disclose it. But we have to have permission slips for the parents to go on these trips. It's not that we're being just trying to give you extra work. It's something our insurance companies require us to get. It also shows that you have the authority to take the kids off the campus here today or wherever the trip's going to be. So that's a written document that we need. Principals, assistant principals that are dealing with vendors. A lot of times these copy machine companies, Monroe Office Equipment, where all my buddies work, they're good folks. They'll come in and they'll tell you that, "See this copy machine? They'll show it to you. Look, this sucker copies, staples, highlights, and delivers the copies to the teacher's classroom. All you gotta do is sign right here. But when you flip the contract over in the fine print, it says, this contract shall be governed by the law of the state of Philadelphia. If you are dissatisfied with this product, if you agree to sue us in Pennsylvania State District Court, you have to pay our attorney's fees. It's got all that stuff in there. So principals, assistant principals, teachers, if you're signing contracts for uniforms or anything, read those contracts and never sign them. Always go up one grade ahead of them is what I like to say. Take that contract to the principal because he or she will know we got to take this to the central office. We got to let bookkeeping look at this. We got to let our chief financial officer look at this because there can be financial obligations here. Contract may be automatically renewing. So never sign these contracts blindly. Never accept the representations of the copy salesman or the equipment salesman. If they're promising you free ink or free toner for a certain period of time, that needs to be in the contract itself. If they're saying it's under a warranty, 5 years, that needs to be in the contract itself. So be very careful of these documents that you're signing. So make a note of that. Other loose ends that I want to talk to you about is bus drivers. Let's talk about operators. Let's talk about how we handle traffic stops. If you're pulled over in your private vehicle on a weekend or after hours during the weekday and you are pulled over on suspicion of DWI, please be aware that if you refuse the test, that you may that you may be unable to drive a bus for 10 years. 10 years. Because the law says that your license will be suspended for 10 years if you refuse the test. Now, if you blow and you blow hot, you're also going to be subject to not driving a bus for 10 years because your license is going to be suspended. At least you got a 50-50 chance, okay? So, I wanted to call that to your attention. Cell phones, pagers, and pistols was another one of the things I had up here. We've already learned that cell phones can be possessed by students. We've learned that they can't be owned. We talked about not going into them unless you have suspicion. I forgot to tell you about the case in New York where the principal went through the directory on a kid's phone and was calling people's cell phones, trying to make them ring in class. Okay? Send them a text, where are you? What's up, dude? Trying to get them to respond. The court called him Rambo principal and said that he could not do that and kids could not be punished for that. Let's talk about our cell phones as teachers. When we start getting close to home now, we as teachers cannot be utilizing our cell phones either in front of the kids during the classroom instructional time and things of that sort. I'm getting more and more reports about teachers being on their cell phones during instructional time. It always boggles me how if we have an emergency at school, sometimes our teachers are posting that on Facebook. Our own teachers, where our principal is trying to calm everything down, trying to use robocall, trying to get it out to the appropriate media. We have teachers that are putting it on Facebook. Mom threatened such and such school. Somebody's acting crazy at such and such school. We need to refrain from doing that because we are being counterproductive. We are directly opposing best efforts of our principals and our central office administration there. So be careful with that. But as it relates to additional technology, your own computers in your classroom, you do not have any privacy in your computers. You read the policy manual, you'll notice that your computers in your office or school board computers, they're subject to inspection and monitoring at any time. It can be monitored from the central office. I had a central office employee last year that was terminated for downloading porn videos and all types of stuff through a file share software where you go out on the internet and record it onto to his computer. And we have this guy who's retired from the FBI, very reasonable. He can come in and pull anything off these computers. So if we're asked to get something off those computers, it's pretty easy to do. But what this teacher was doing is he was not wanting to pay the 10 or 15 bucks it takes to go to the movie. He was getting movies from overseas before they were in the theaters. He was downloading. And the way the internet works is that on some of these websites, when you create that link with that website, you create a crack in the firewall of the school system. So people were coming in through that crack and coming in through our firewall and getting some of our information out. So this was not simply, let the man watch the movie. This is a situation where that confidentiality was being breached because he was going out through these sites that have these viruses and other things to allow people into our own district. So be careful there. We talk about student-teacher relationships. Don't even place yourself in what appears to be an appearance of impropriety. Harassment and bullying, we know that we go through training on that each year. We know that it's here to stay. Now, the thing that gripes me is the suggestion that bullying just started 2 years ago or whenever that law was passed. As long as there's been 2 kids on the playground, folks, there's been bullying. I promise you that. Okay? I remember being the big kid that's kind of slow. When you divide up big teams, you kind of get picked last. Okay? When you read the definition of bullying, shunning is one of the terms in there. I really think that John White, those guys down at Baton Rouge, they sat down and said, what do kids do? Oh, they stick their tongues out there. Ooh, that's a good one. Right there. They shun. Some of them, they don't pick people. Oh, shunning. We'll put that down. Making facial gesture. In other words, they put everything that kids do in there, and if it's a repetitive deal, then suddenly it becomes bullying. So don't tell me bullying is now got out of hand. Bullying has been on the books as long as there's 2 kids out there. But we cannot ignore it. The parents can leapfrog the school district and go straight to the Department of Ed if we are viewed as not having followed our own policies and our own provisions in our handbook. So if you have reason to believe that there's bullying, or if there's a bullying complaint, follow your policy, make the appropriate reports. We talked about mandatory child abuse reporting. I want to talk to you again about your language because it's in that policy, GBRA. Kids can be reporting you at any time, so be on your guard, okay? Watch your P's and Q's. As it relates to letters that you write to parents, or things that you put on your bulletin board, or things that you put on your your web page, for those of you that have a school-based web page, be extremely careful of your spelling and your grammar, because it is extremely embarrassing to read on the parents' Facebook post that my child's English teacher is trying to teach English, yet is having subject-verb disagreement in her letters or his letters. Same thing with principles and your observations and evaluations. Be careful of your grammar and your punctuation and your word use there. Okay? All right, so we're going to take one final break. We're going to come in close to 11 o'clock, and we're going to finish up that last hour, and I'll let you out of here. Thank you.